Yes, I agree. The judiciary has come under scrutiny of late, mostly because of political activities. And your political activities come with so much
baggage.
So you can expect that when it doesn't go a particular way, people feel some waters has passed under the bridge. Meanwhile, sometimes if you look at it critically, if you look at the situation, or if you look at the reasoning behind the judgment, it's just a storm in a teacup.
So are you saying that in that case, water does not pass under the bridge, and then people don't have to ask questions and say, okay, so how did he arrive at this? Or probably he's just being a stooge to a particular political party or executive.
Well, you see, it's very difficult to convince someone who has lost in court that the judges were fair.
He who plays the piper dictates the tune. How exactly would you react to such, saying that no matter what, even if come rain, come shine, the executive would always dictate what every judiciary does, be it state or at the center?
Let me take you back a little bit to the Obasanjo era.
Okay.
Obasanjo was a very strong president. He was a hands-on president. He wanted dictating to every institution how things should go. He wasn't able to control the judiciary. Yet, it was the federal government that was giving money to the judiciary. As a matter of fact, Atiku took Obasanjo to court 7 times. Defeated him all the 7 times. Is it that Atiku had more money to give the judges? Or is it that Obasanjo did not have the money or the influence to influence the judges?
We'll begin this conversation taking our quote first from Caroline Kennedy. Once said, "The bedrock of our democracy is the rule of law. And that means we have to have an independent judiciary, judges who can make decisions independent of the political winds that are blowing." Absolutely spot on. My next quote is from Andrew Jackson, and he once said, "All the rights secured to the citizens under the Constitution are worth nothing and a mere bubble, except guaranteed to them by an independent and virtuous judiciary." My last quote is from David Liddington, once said, "The rule of law and the independence of the judiciary underpin our democracy and lie at the heart of our way of life. They are the very cornerstone of our independence." Absolutely spot on. My last one is from Prashant Bhushan, once said, "Independence of judiciary means independence from executive and legislature, but not independence from accountability." I quite agree with that one. Now let's see how this quote relates to what we'll be discussing today. Very warm greetings and welcome to The Conversation. We are reaching you from KAFTAN Television Studio here in the nation's capital, Abuja. I am Annabelle Oji. Now, we will be talking about the Nigeria's judiciary since 1960 or even before then, but up until now, since 63 years of our legal system, what has been happening with regards to the trials, fair trials, and then we'll also move straight to the NBA. How far has their members been faring? How far have they been able to deal with their welfare of their members and even young lawyers? I recall having discussion with some young lawyers who expressed disdain of how much they're being treated, especially from the experienced lawyers. But then we'll deal with all of that today on the show with my guest, who is Barrister Oko Pascal Adinya. He is an attorney. He will help us to analyze all of these stories after this time out. Let's go on a quick break and we'll be back to start these conversations. Ladies and gentlemen, welcome to The Conversation. Welcome back. If you just joined us, this is The Conversation. We are reaching you from KAFTAN's television studio here in the nation's capital, Abuja. Now we'll go straight to our conversation for today. And my guest is Oko Pascal Adinya, who is an attorney. Great to have you on the show today.
Thank you very much.
Awesome. All right. So now let's go straight. Let's talk about Nigeria's judiciary. let's go first of all to the general before we come down to the specific. And then if you're looking at Nigeria's judiciary since independence, or since after independence, if you have to look at the era when we had to take judgment, or we had to take decisions from the colonial masters or from the Queen, and then up until now, when when the Supreme Court was set up, and then up until now, how far would you say that, or how independent would you say that Nigeria's judiciary has been since the last 63 years?
Oh, well, in my opinion, I would say the Nigerian judiciary has done very well. Very, very well.
Oh, really?
Yeah.
Okay.
Coming up to the point we were taking decisions from England, cases were coming from the Lord's Court from the UK, until we found our feet and started having our court. The judiciary has actually done very well, particularly in our troublesome military eras. Much as they were decreased to emasculate the judiciary, they were threats, the judges were able to hold their own, and they gave fair judgments, sometimes very brazen judgments in the face of threats. And then, down to our democracy, First Republic, Second Republic, down to the Fourth Republic, the judiciary, in my view, has actually done very well.
Okay, so I hear you say that they were able to give fair judgment, but then we'll talk about that later. Now, if you have to look at, and I hear you also talked about during the military era, and then now as we are in the civilian era, some people will definitely tell you that it's actually better we go back to the military era when things were right, people did things the right way, and then you had discipline, you have the Kai, you have the Y, you must line up well, cues and all. There was discipline at that time, and then also it goes down to the court. But these days, because I remember the former military president Ibrahim Babangida said that if they have to look at the corruption that happened in their time, and if you have to compare what happened in their time and now, it's far worse what you're seeing now. And because in all of this, you cannot remove the judiciary in that equation. So how far would you say that if you look at what happened during the military era and now, how would you say that the judiciary has fared, especially in terms of delivering fair judgment rather?
During the military era, the judiciary was not that exposed to political cases because, of course, there was less politics. During that time also, there were exclusion clauses which the military stopped the judiciary from diving into or even deciding or sitting or presiding on certain areas. So the judiciary was more or less narrow. It was narrowed and tailor-guided towards what the military want. Most of the cases of human rights that came before the judiciary about that time were the cases that defined the judiciary. Now, under the civilian government, you have politics, and we operate a multi-party politics that exposed the judiciary to so many cases. As a matter of fact, political cases take more attention of the judiciary. And with that political cases comes exposure. And you know, politics is played with emotions. And most people feel the judiciary should take a particular decision leaning towards their emotions. Meanwhile, the judiciary is a court of law. They operate under a court of law, not court of sentiment, not court of public opinion. And the nuances of how the
So I hear people always say that judiciary is not a Father Christmas.
Yes, the courts have ways through which they go through taking decisions. So if you don't know, sometimes you will question. You know, people will just only tell you the decision taken. They may not give you the background that led to that particular decision. And then people go home with, oh, the judiciary is corrupt, the judge has collected bribe, without even knowing that sometimes these judgments go before a court or a panel. Maybe at the Court of Appeal, there are sometimes 5. At the Supreme Court, 7 or 5. And there are some dissenting judgments. There are some judges that say, no, I prefer to say this way, others prefer the other way. Now you start asking yourself.
Can you actually do that at your own discretion? Decide what you want to say, the way you want to say that?
Of course. The judges are free to decide how they want. It's not a teleguided thing. That is why you have a dissenting judgment. Some saying, yes, we agree with this. Some saying no. And then the majority is what the judgment holds. So if you're saying the judiciary is not fair, in that question, how do you arrive at a panel of 5 taking different decisions, 2 to 5, 2 to 1, or in some cases, yes, a whole panel agree that, okay, fine, we are going or suing the same side. So apparently, you can see that basically it is the news that goes out there to the public. The public is dealing with the decision without going into the nitty-gritty of how did the court arrive at that decision. And sometimes lawyers actually don't help matters. If you lose a case, it is expected that you have an option of appeal. If you don't have an option of appeal, the courts have decided. Even if you are going to disagree with what the court says, it shouldn't be a newspaper thing of calling judges' names, saying the judiciary is this bad or that bad. Yes, I agree, the judiciary has come under scrutiny of late, mostly because of political activities. And your political activities come with so much
package.
So you can expect that when it doesn't go a particular way, people feel some waters has passed under the bridge. Meanwhile, sometimes if you look at it critically, if you look at the situation or if you look at the reasoning behind the judgment, there's just a storm in a teacup.
So are you saying that in that case, water does not pass under the bridge and then people don't have to ask questions and say, okay, so how did he arrive at this? Or probably he's just being a stooge to a particular political party or executive?
Well, you see, it's very difficult to convince someone who has lost in court that the judges were fair. It's very difficult. But when the person loses, oh, wonderful judgment. Even people who are postulating today saying the judiciary is corrupt, they've been wonderful beneficiaries of what the judiciary has done to them. So many, the politicians included. The politicians were at the point the judiciary was their saving grace. The justice stood their ground and said, no, this is wrong. And, you know, through the instrumentality of the court, they were either reinstated or the upheaval which was coming towards them was taken off by the court. But now that maybe it's going the other way, they hardly remember that this was the same institution that was there for me when I was in bad times.
All right, now, what would you actually say, or how would you respond to that argument saying that the judiciary is just they're actually tied to the apron strings of the executive? You have because most people come out to tell you that after all, in most states it is even the governors that give that either give them their vehicles or give them some kind of income and all. So definitely they'll tell you that he who plays the piper takes the tune. How exactly would you react to such, saying that no matter what, even if come rain, come shine, the executive would always dictate what every judiciary does, be it state or at the center?
Let me take you back a little bit to the Obasanjo era.
Okay.
Obasanjo was a very strong president. He was a hands-on president. He wanted dictating to every institution how things should go. He wasn't able to control the judiciary. Yet, it was the federal government that was giving money to the judiciary. As a matter of fact, Atiku took Obasanjo to court 7 times, defeated him all the 7 times. Is it that Atiku had more money to give the judges, or is it that Obasanjo did not have the money or the influence to influence the judges? Boil down to the question you asked. Yes, money comes to the judiciary through the executive via budget. Mostly at the state level, it is very true that sometimes the judge have to go cap in hand seeking money from the governors. That is true, which is an abnormal situation that should not be encouraged. But that does not mean that the judges must tailor their decision towards what the governors want. We have cases where the ruling party in this country has lost its sitting governors. Is it that the federal government did not give the judges money? We have cases in this country where, in apparent disregard to what the executive want, the judiciary still went ahead to do that which they want. Yes, there are challenges in the judiciary in terms of funding, in terms of providing materials. Like for now, judges are still writing in longhand, which is very strenuous. There are those areas that need improvement. But that is not to say the judiciary is helpless and must tailor towards what the executive wants for them to get what they desire to get. Agreed. It is not Uhuru in the judiciary as in everything is very perfect. No, there are lapses. It's actually the workload on the judiciary. If you go to court, most judges in the FCT, in the Federal High Court, sit on cases like about 15, 20 cases on a court list. And most times, it is required of them to write in longhand over these cases. So those are areas that if the judiciary is funded, it can ease the work of administration of justice. That said, that is not to say, however, that the judiciary is so helpless that it is tied to the apron string of the executive.
Now let's talk about cases, trial that you have that have been pending for a very long time. You go to prisons and then you hear of someone who has been put behind bars for years, and then you just begin to wonder, have they actually forgotten this person's case? How exactly can we deal with that issue of very long and pending trials?
The administration of criminal justice actually will not stop at the buck of the judiciary alone. It has also to do with the law enforcement agents. Sometimes, or most times, these cases stay that long at the instance of the law enforcement agents. Let me give you a typical example. You arrest someone for armed robbery. You charge the person in a magistrate court that do not have jurisdiction to try the person. You've taken the person before the court. The judge will not just say, go free. Neither will the judge say, okay, I'm granting you bail, because that offense is bailable only in very special circumstances. Okay. And more so that the judge at the magistrate level do not have the jurisdiction, he sent the accused person to remand. The accused is remand. It is the duty of the prosecution agencies to now get legal advice out and charge the accused person in the proper court, which sometimes take years. Now, when they finally move to maybe the high court, where the person is probably now charged, you have the issue of 2-3 years have passed. The police investigation officer on transfer. We have sent a signal, he couldn't come. He didn't receive signal. The adjournment keep going on and on and on and on. In fact, in some cases, judges get angry and say, look, in the next adjourned date, if you don't have your witnesses, I'm striking out this case.
What happens when this case is being struck out?
Yeah, it could be, they could strike it out. But, you know, as usual, the police can still arrest you.
Ah.
Yes, much as the matter is struck out, the police can still arrest you. Except if you have good legal representation where, okay, a fundamental human right could be filed in your favor, seeking that, okay, fine, the other charge you to court will grant you bail. So the judiciary is bedeviled with so many bad names, not really in the real sense of them. Sometimes it's just simply not the judge's fault. Sometimes it is lawyers that deliberately, slow the process.
Why so?
Fine. You talk of fair hearing. Now, the administration of criminal justice has introduced rather new elements into the trial of criminal cases, if not before. I will file an application before a court. If that court rules against me, I move to the Court of Appeal. As I've moved to the Court of Appeal, I file an application that matter should pen before that court until the Court of Appeal rules. It takes a year, 2 or 3 for the matter to go to Court of Appeal. By the time it's finished in Court of Appeal, it is still against me. I file a Supreme Court.
Supreme Court.
I still say, look, wait until the Supreme Court decides. All these years, the matter is hung there. The novel now introduces you cannot stall it, even if you go on appeal.
Okay.
The matter still continues. If not before, those are some of the issues that we are stalling criminal cases. And even at that stage, you have very frivolous applications coming in. And once the judge maybe refuses to take it, oh, fair hearing. He has descended to the arena, he doesn't want to give me fair hearing, and you have issues of, okay, recuse yourself, you've descended into arena, I don't have confidence in you. These are little techniques and shabby things that happen in the court to frustrate the administration of criminal justice.
So I hear you. I'm trying to remember the word that you just used. Like, so if you have to talk about cases that are just clear waste of time, what cases do you would you actually describe as, oh, this case is just a total waste of my time?
There are some judges that really don't take nonsense in their courts.
So it depends on the judge?
Yes, there are some judges that really sit up. For example, it is required that if you're filing a criminal charge, you should have with it the supporting evidence. You front load it. That is proof of evidence. This is what offense I'm charging this person with. This is the proof of evidence that witnesses I intend to take. Some of these charges are on political nature. Some of them are trump-up charges. Some of them are just, I want to show you I'm a big man. Some judges, by looking through the proof of evidence, they discover that, look, this doesn't need to be in court. They struck it out.
Okay.
Yes, they struck it out. Or if they give you enough time to prosecute and they say that you are not doing what you're supposed to do, they still strike it out. And sometimes they strike it out and they refer you to the Attorney General or the Solicitor General. Give this ruling to the Solicitor General or the Attorney General. Let him know this is what these people are doing. Instances like that abound.
Ah, okay. Okay, so now I also hear you say that the judge might decide to strike out a case and all. Now let's talk about, and then I hear you talk about someone might decide to just do, I'm a big man, I want to intimidate someone. Now let's talk about that. I know we've always had that issue of that discussion of where you have conflicting judgments. You have in one court it has been settled, and then they take it to another court of competent jurisdiction, and then you just begin to wonder. And at some point, you just have one, probably a politician or probably one business person that wants to deal with someone and decides, okay, because I want to punish that person, I go get an ex parte order, and after that, he has passed through one court, they want to take it to another court again. How do you actually deal with that issue of conflicting judgment? I know how many times the Attorney General of the Federation has talked about it, how many times the Ministry of Justice has talked about it, but it is still a quagmire that needs to be settled. How do you settle the hydra?
That mostly happens in civil cases. It hardly happens in criminal cases because of the doctrine of res judicata. They have mischief. Lawyers filing applications. Sometimes it could be different lawyers, but one thing. I file in this court, you file in the other court. What the judiciary is trying to do in that regard is they try to streamline the process. They're trying to make sure cases filed. That is why you have some provisions where you have to undertake that this matter is not filed in another court.
Ah,
yes.
Is this done recently?
Yes.
Okay.
Yes.
Okay.
There are some provisions under the rules that you undertake that this matter, as you filed it, it is not filed in another court. And also, when you file cases, they go to the presiding judge, either the judge of the FCT or the chief judge of the Federal High Court, for the cases to be assigned. They are meticulous to see that as much as possible they reduce proliferation of cases where the same cases in Federal High Court this, same is in another Federal High Court this. They try to consolidate and put them in one place so that the issues are joined and the matter is taken up once and for all.
So is there a way that you know that if a case is coming from, for instance, Maiduguri, the magistrate court in Maiduguri, it has been settled there, so someone now decides to come down to Lagos and bring that same court, how would that judge or the court in Maiduguri settle that case, and then probably is there a way to follow that case as it goes?
Technology.
Do we have that technology in the judiciary now?
Yeah, the federal
Even though you're complaining about the judges writing with their hands?
Yes. In the Federal High Court, for example, where you have Federal High Court of different jurisdictions throughout the Federation, they try to streamline and know which case is before whichever Federal High Court, so as to avoid this kind of, having same matter, same subject matter in different courts. Judges are humans. Some people look at the glass as half full, some look at it as half empty. So if the matter go to different courts, the appreciation of law is based on how a particular judge sees it. It's only the principles that are the same. The principle could be the same, but a particular judge could look at the provisions, the facts, and the decision in a different light. That is why you even have dissecting judgment between a particular panel. So that could not even be deliberate. But it is better that a case dealing with same facts, same parties, should be streamlined and handled by one court instead of having conflicting judgments from different courts. So Federal High Court, I give it to them, they try to streamline it. Even within the FCT High Court, they try to kind of restrain the issue of same parties, same matters being in different courts. Most times when they know it, they try to consolidate it, and the matter is handled together once and for all.
Okay, so I also hear you talk about some lawyers who will be mischievous. So now, if you look at the fact that, especially in these political cases, some people, most Nigerians will come out to tell you that the reason why they decide to take up this case, and they know that there's no fact, there's no evidence. They keep running after it because they want to collect money from either that political party or the politician. Is that true?
Well, you see, it's difficult for you to go to a hospital and the doctor tells you, no, nothing's wrong with you.
Or it's a mechanic.
At least they could tell you, okay, you can take some Panadol, you can take some. But in the reasons of it, let me be a bit blunt about this. Some lawyers just decide to take their chances.
Oh, chances.
Yeah, they know that the facts are bad. They know that the case is bad. But they take it all the same. And that is why at the Supreme Court or at the higher courts, courts of superior records, they are slamming punitive costs, measures on lawyers who take those kind of cases. You make such a frivolous application before the Supreme Court, they slam you with punitive costs in your person.
Is it financial?
Yes, it's financial.
Okay.
It's financial. Financial sometimes.
That's individually or to that chamber?
Individual.
Oh, okay.
Individual. And when you file a process, your name is on that process. You move the application, so the court now give it directly to you. You should pay the sum of maybe 10 million, 5 million to so person for this frivolous application. Yes, the court is doing that to discourage situation whereby very frivolous applications are filed in court.
Great. All right. Clearly, there's more we can still unbundle from this conversation with Barrister Pascal Adinya, and we will definitely get right to it after we come back from this quick break. Join us again. Now, is it the issue of coordination that affected that fracas you had during the recent NBA AGC, where you had the NBA president and the treasurer had some face-off, and then most people ask, please, why do you have to wash your dirty linen outside?
Where there is money, there is problem. Yes. And at the annual general conference of the bar, it's about the most serious gathering of lawyers. So anybody who have a grievance feel, this is the place
to air it.
I can air it.
Aha. Welcome back. If you just joined us, this is The Conversation. We're reaching you from KAFTAN's television studio here in the nation's capital, Abuja. If you just joined us, you've actually missed out on the first part of the show, but you can still join us as we still have Barrister Pascal Adinya, who is an attorney. Okay, before we went on that break, we've actually spoken quite about a number of things, and then now let's come down to the NBA. How far would you say that the NBA is faring with regards to, from all of the administrations you've had since time immemorial till date, and then how far would you say that they've been able to deal with the issue of welfare? I'm going to ask you two questions and I'd like you to take them together in one breath. Now, how far would you say they've been able to deal with welfare of their members, especially in the NBA? And then also talking about young lawyers. We've had situations where we've had to talk to some young lawyers, and then it looks as if they just abandon us, and then it's just the experienced or the higher ones in the hierarchy that are being taken care of. So how far would you say they've listened to their young lawyers and be able to, at least to an extent, make them feel good, if that's the word?
The NBA have a lot on its hands. Lawyers are many, and trying to streamline the process of taking care of junior lawyers, it's tough, but the association is bringing in some model innovations on how to tackle that. For example, there is an NBA insurance, where they try to insure young lawyers. There is a forum the NBA is trying to ensure. There's mentorship, which is far more important anyway, because most lawyers are after law school. They hardly have someone to learn with, and if you do not learn, the practice of law is more or less a learning process, a learning curve. You attend court with senior, you see how the processes are argued. From even filing, you see how it is filed. You see from the preparation of the case. Legal practice is like more or less. I gave an instance of a doctor. Before you operate someone, you prepare the person, you check the person's pulse. Is his blood pressure okay for this operation? You check all those things before you go ahead. That is something happen in legal practice. Once you receive a brief, or if a brief is served on you upon it being filed in court, you dissect the meat of what the whole process is about. So if a lawyer is under a senior, he or she learned through these processes on how to handle cases in court, how to approach certain matters. Some matters are actually very technical. Now, mentorship is very important, because that is the only way you can get through the process and then cut your own teeth in the profession. Now, also individual lawyers, some seniors are doing wonderfully.
Okay.
Yes, there's some individual lawyers like Kanagabi SAN. Kanagabi SN has a very huge building in Mabuchi. The office space is given to lawyers, young lawyers, for free.
Oh, wow.
You only pay.
Oh, they were supposed to pay for it?
No.
Are you supposed to pay for a space?
No. You pay a token. No. You don't pay for the space.
Okay.
You could have 3, 4 lawyers, 5 lawyers in an office. All you do is you pay for the maintenance of the building, because the building needs to be swept, the environment needs to be clean, the staircase, the corridors need to be mopped.
Or like the service charge.
Yeah, only something like that. Pay for only the service charge. And then I think there was also a microfinance bank he was trying to raise, so lawyers could collect soft loans to handle other issues. And of course, the likes of, I think Afe Babalola too, was doing something in that regard. So many other lawyers have their own personal schemes of how to help younger lawyers. By and large, the NBA, I feel, need to really up its game. Much as they're trying, they need to up its game, because the practicing fee is huge, the membership is huge, and they say to whom much is given, much is also expected.
How much is the practicing fee?
Practicing fee is paid based on the years.
Okay, of
Yeah.
experience.
Yeah, from 1 to 5, you pay different. From 5 to 10, different. 10 to 15, different. 15 to 20, different. The body of benchers pay differently. Senior advocates pay differently, so on and so forth. It's not a standard cut across board.
Okay, so because I asked them earlier, I'll bring back that question. How far has it been since the days of the formal administrations you've had? Because I know most times when you talk about the NBA, most people are always, most lawyers especially, they always want to go back to the days of Alao Akabashoro, the days that was like the glory days of the NBA. So how far would you say it has gone? That's one on the side. And secondly, I remember talking to a lawyer, and then he says that if you want to know which administration of the NBA has done really good, it's time when it is time for the NBA AGC. If you get your lawyers, is it the bag, the souvenir very quickly, and then what is inside the souvenir, that tells, okay, this administration is really doing better. What will you say in that regard?
Well, the NBA is evolving. In the days of Aka Bashirun, the law was not that big. You didn't have a lot of lawyers. At present, you have a multitude. Yes, at present. And also, you know, ambitions. Those days, yes, there was ambition. To a point, it even gave NBA some problems, but they were able to rein it in. Now also, because of, should I say, maybe financial benefit in the NBA, a lot of ambitions come across. NBA has evolved actually. Before, you didn't have a secretariat. NBA has its own secretariat built, furnished. They operate from there. The problem we have basically is that of proper coordination.
Okay.
Yes, proper coordination in the sense that the branches are far apart, and the center that is supposed to coordinate, I believe the synergy with the branches is a bit not too strong. In the sense that, for example, lawyers in Abuja have their own thing doing. Lawyers in other states or other branches have their own thing doing. And if the NBA could kind of try to aggregate a formula, or better still, a middle ground of how to reach out to its branches, I think it will.
And I know you have
help.
over 100
Yeah.
of them.
Yeah, very many. Yeah, some states have about 6, 7 branches, some 8, 9, 10 branches put together. So it's a matter of, let's say, NBA finding a way to relate with its branches, to make whatever decision they're taking, to trickle down to those branches to help the young lawyers grow.
So now I hear you talk about coordination. Now, is it the issue of coordination that affected that fracas you had during your recent NBA AGC, where you had the NBA president and the treasurer had some face-off, and most people ask, please, why do you have to wash your dirty linen outside? What is happening in that way? What can you tell us?
You see, where there's money, there is problem. Yes. And at the annual general conference of the bar, it's about the most serious gathering of lawyers. So anybody who have a grievance feel, this is the place
to air it.
I can air it.
So
I wouldn't know the nitty-gritty of the financial or the discontent or the disharmony they had. But one would have thought that this is an executive. They should work together. If they have issues, there are mechanisms within which they can pass through for those issues to be resolved. But as I earlier said, it's an annual general conference. Everybody that matters is there. So they feel, okay, if I say it here, ripples effect to be created. So in my opinion, that forum was used to
say air grievances and
Yeah.
wash dirty linens.
which is not proper anyway.
Aha, most definitely. All right, so now would you actually say that the Nigeria's legal system has is doing the average lawyer, Nigerian lawyer, even be it the young lawyer or the experienced one, would you actually say that they're doing them a lot of disservice? Because you have one lawyer would come out and tell you have so many cases, and then I'm trying to look for the right word. I think a dime in a dollar. They just have plenty cases everywhere, and then you're just wondering at some point, this one are just charge and bail lawyer. So is it the Nigerian legal system that is doing these lawyers that disservice, or they are the ones that are doing that disservice to themselves?
You see, the practice of law is dependent on skills. If you are good, if you handle a case and you are good, people will recommend you, oh, this person is good, let's go to him. You understand? That said, also the mentorship I had mentioned earlier. If you learn from one of the best or someone that is good, you are bound to take the traits of that person. Now, also, on the issue of charge and bail, it's just maybe indolence. People who choose not to be serious about practice. If you are serious about practice, there are certain things you will not accept. There are cases you could reject. Tell your client in the face, I can't take this case for this purpose. But, money is the driving force. So some people take cases they ought not to take. And I can also say some lawyers, most lawyers don't tell their clients the truth. Yes. Sometimes you have a very bad case. A very bad case. And you are being told you can do it. I've had experiences like that. You have a very bad case and the lawyer tells you, don't worry, we can do it.
Define bad case for us.
Bad case is a case in which the facts are seriously against you, particularly in criminal cases. I'll give an example. I won't want to mention names. I was in court and a judge recommended a particular case to me that was brought by the FCC. They charged the young man to court and he didn't have a lawyer. So the judge asked me to take the case, of course, pro bono.
Okay.
They can do that. So I took the case up and I went through the file. He had 3 confessional statements in the proof of evidence that the ES is attached. Also, they have facts of some marked money that was given him. He accepted to the offense. The statements were made not under duress. Now, in that case, what is the right thing to do? Will I still tell him, look, I can pull you out? It was difficult. And I had audience with his lordship. He asked me, I've gone through the file, what is my opinion? I said, it's a bad case. And in our discussion, he said, well, he has seen the case that is bad. And if the young man changed his plea from not guilty to guilty, he has a life to live. You give him a sentence of a year or 2, let him have his life thereafter. Meanwhile, he was sent to prison custody because the case came in court. I had not applied for any bail.
Okay.
And it was slated for 2 weeks. When 2 weeks came, another lawyer appeared for him.
Oh, wow.
And of course, I had to excuse myself. Yeah, so I excused myself, and the matter went on trial for about a year and a half. I was sentenced to 14 years imprisonment. What I'm trying to say in essence is, this is a case that was bad. Sometimes when you do something wrong, you can let the court know, I'm remorseful.
Okay.
I'm sorry I did this. The court can, that's what they say, you tamper justice with mercy. The court could look at the circumstances, do not waste the court's time. There's an allocutus in your behalf. Probably maybe you are a first offender. The court consider your age, and you are given a sentence that should be for purposes of reforming you. You understand? But by the time you go through a whole trial, putting the court through the stress, They give you the maximum. So lawyers actually, as I said, sometimes don't tell their clients the truth. The case is helpless, and they go ahead and take it up.
All right, so now let's come back and talk about the 2023 elections. With this, the judgment, the electoral tribunal and all. First of all, let's start with that electoral tribunal. Have a lot of people who tell you that courts are oversaddled with too many cases already, so we should not bring election matters. We should just take them away from the normal court. Do you agree in that regard?
They're already taken away from the normal courts. That's why you have election petition tribunals.
So then, but then you still come back to the appeal court. You still go back to the Supreme Court.
Yeah, that is because you give room for them to ventilate to the last. You have a classes of political cases. You have pre-election matters that go to the regular court. You have the post-election matters that goes to the various election tribunals. Now, in the tribunals, if you are for the House of Reps or the Senate, you stop at the Court of Appeal. It is for the governorship and the president, it goes up to the Supreme Court. Those are the safeguards that the law has tried to make to curtail the matters in court. And also, they are tagged with days, 180 days within which you can prosecute it, and it's gone and done with. So you cannot completely take away political cases from the court because the political parties themselves are not doing the right thing.
How do you mean?
Political parties have rules. The political parties have their laws that they're supposed to follow. They will not follow. And once they do not follow and someone feels aggrieved, where is to go? Down to go to court. So there have to be a lot of internal democracy within the parties. If you want to reduce the workload on the judiciary, the politicians need to do a lot. Their own very rules that they make, they still don't follow them. Forcing people to take the matters to court. It's not the court that sits and say, okay, bring these cases, we want them. It's people who file those cases before the court because they feel there's a grievance. And you cannot shut the door to someone who feels aggrieved. You have to look into it. And sometimes, most times, you see that what the political parties do is very ugly. All
right, then. Today's headline says, on the Nation's newspaper says, Supreme Court grills Atiku's lawyers over CSU document. If a sitting president, if you get that judgment from the Supreme Court, if a sitting president gets that final judgment and then he's been unseated, what happens?
It's possible. It's not as if it's not possible. It's possible. But as you rightly say, the matter is sub judice, and I will not want to delve into the merits of arguments or counter-arguments of what is happening. Basically, the Supreme Court is seized of the matter, and the Lord Justices took the argument yesterday.
But I hear you say that it's possible for a sitting president to be
why
unseated.
Not? If not.
But then if you recall, a few weeks or months ago, we had that newspaper headline that says that it will be anarchy if this administration is being unseated. Is that possible, or is just
it depends
words?
It depends on what is before the Supreme Court. You understand? You know, there's so much of media hype about the 2003 general election.
Oh, so are we the one hyping the...
Yeah.
Oh, really?
Yeah.
How so?
The hype is from the media and as well as the lawyers. Much as I will not delve into the Supreme Court matter, let me delve into the one that was already decided by the Court of Appeal. You see, for me, I believe in following facts. The contest for the president of Nigeria is a serious business, very serious business. And after that elections, there were so many cries, oh, I'm rigged out, votes for this person have been taken to this person, votes for this person have been cancelled to this. But if you look at the prelude to that elections, it was things to come. On the 21st of February, INEC published list of party agents. We have about 170-something thousand polling units in the Federation. Each polling unit is supposed to be manned by a party agent. Who is a party agent? Is that person that ensures vote is done properly, my candidates, supporters are not intimidated, the election is collated at that level, that polling unit level, and announced properly. I have a copy of my party's result. That is the work of a party agent at the polling unit. PDP had the highest numbers of party agents at the polling units, followed by APC. The Labour Party was short by over 41,000. 41,000 party agents. You can imagine what could happen to those polling units that they do not have party agents. So, assuming that even in the recence of it, Labour Party was shortchanged, who is there to ensure that that shortchange maybe did not happen, or even if it happened, there is proof to show that this is where I was shortchanged? There's nobody. Now, when the matter now finally came to court, the court said, you say you are shortchanged, but we did not see evidence of which vote from which polling unit was taken away. Rather, emphasis was placed, the result was not uploaded real time. Okay, if the result was not uploaded real time, how did that affect you? If you have had a party agent bringing a result, this is the result from polling unit A, this is what we scored, and what is uploaded on the IREF is different, you have a point, right? This was not done, and somehow people even start imputing meanings that the tribunal was angry in passing its judgment. Why wouldn't they be angry? The tribunal is not insulated from the public. As this noise was going on, they didn't even hear the news. Okay, let's see what is before us. And then, at the end, it was apparently little or nothing. Cases were dismissed, they're not before the Court of Appeal. Before the Supreme Court. If what they have before the Supreme Court is enough for the president to be upstage, why not? It can be done.
Okay.
It's not as if the president's seat is cast on stone and nobody can shake it. No. If the Supreme Court is convinced that there's enough evidence for us to remove him, he'll be removed. That is why it's the Supreme Court anyway.
All right. Even as we begin to round up, let's round up on labor matters and labor laws. You have companies and employers or employees who have come out to complain that we're given some clauses where we're signing our employment letter, and at that time, because I needed a job, I had to agree to it. And so now I've checked it again. I decided to check it with my lawyer, and I found out that those clauses they're detrimental, not just to me, but also to my activities at work. At that point, even though you might have signed a non-disclosure, and you've signed you are not supposed to take the organization to court, how do you deal?
The Nigerian Labour Congress, which is the umbrella body of workers, mostly more organized workers, so to speak, civil servants, maybe textile industries, manufacturers industry, all those ones. It's not up and doing at the moment. You can see the vibrancy in the labor days of Oshomoles, Pascal Adinya are no longer there. It is true, we have serious unemployment problems, and employers of labor are cashing in on that to provide unfriendly, sometimes even obnoxious employment conditions. People feel, well, I have to eat. So sometimes when they really start and they discover, They don't, it's not as if they don't even discover it. Sometimes they know it, but they feel, okay, I can weather it. But after they discover that, look, this is strenuous, and they try to wriggle out, issues of use of the contract now comes in. But it is also the duty of the government to ensure that conditions of service for work in any place is not obnoxious. You don't more or less give somebody very unfavorable terms of work that you are employing the person because there's no work. There should be some humanity in us that, okay, fine, these are basic, not some draconian provisions. There's some workplace that they even tell you, don't dare bring your baby to work.
Most definitely.
Yeah,
yes.
There's some places they say those things. So if you're a nursing mother, imagine how do you manage? So there are a lot that is going on. There's a lot that is going on. Some even at the end of the day, your salary is not fully paid. Reasons are given for a shortage, and those reasons really do not flow with labor practices. So these are areas that the Ministry of Labor and Productivity will need to look at. But you know, the problem we have again is the country is very big, and it's very difficult trying to pin down these sort of things. And the worst part of it all is that we don't accept regulations. Neither do we accept to be monitored. Even people who are supposed to monitor, they hardly do that.
That's definitely. So now, if you have that nursing mother watching us right now, that her office says don't come with your baby and she does not know what to do, or if you have someone, an employee who is watching us right now and say they have that obnoxious agreement that they signed into, what would you actually tell them to do? Is it sue or just move on with your life?
It depends on the circumstances of each case. It's not one shoe fits all size.
Okay.
Particularly on issues of family. You know, a court could look at it and decide this is draconian and we should not allow it. So it depends on the circumstances. It's not every regulation, so to speak, that you can want to litigate on. But on issues like maybe nursing mother, you should encourage family. You should encourage the welfare of the child. It should not be at the expense of you making money, particularly the organization employing now. It should not be at the detriment of the family setting, because in any case, that is what holds the society together. So there are some of these instances as if you litigate on, you could get reprieve.
Okay. So even though I've signed that I'm not supposed to take you to court, I can still take you to court.
Of course, you cannot legislate the court out of a contract. That becomes an illegal contract.
Okay.
Yes.
Thank you so much, Barrister Pascal Adinya. It's been a wonderful time having this talk with you.
Thank you very much.
All right, viewers, that's where we end this conversation for today. What a fine place to anchor this conversation. It's been a very wonderful time having this discussion with Barrister Pascal Adinya, who is an attorney. Thank you so much for listening. I'm sure you must have been rightly educated, entertained, and informed. I will see you next time. My name is Annabelle Oji from the nation's capital, Abuja. Have yourselves a very wonderful day. God bless you and yours. God bless Nigeria.